it's great to see that not only is this room full, but that there are some people in an overflow room joining us for the kickoff event of the 2016-17 academic year for our Lawyers Community and Impact series of events. This is something that grew out of conversations that I had with many student groups the first semester I was here as dean. The spring of 2015, I met with many groups and many students individually. And in addition, we created a task force on student life that had a number of faculty members who are people who've been historically really engaged with student life, with their task being to think about ways to make student life at Columbia more vibrant, to build thicker, more meaningful community. And actually, Professor Johnson was on that committee. And one of the things that came out of it, we also had a curricular task force, and the same message flowed out of the conversations that another group of leading thinkers about our curriculum were having. And one of the things that came out of it was that students really craved the opportunity to have conversations and to form ties outside of the podium classroom, and outside of the context where you're in a small seminar and you really get to know those 12 people. So the question was, what could we do to create opportunities to build community more broadly that are outside the classroom? But another thing that came up that was really critically important was people really crave, and this is a value that I share very deeply, the opportunity to think about the things that you're learning in the textbook and to be able to understand them in the context of the world around us, to use what we're learning here in law school not only for our professional development, but to gain perspective on ourselves as agents in the world, agents of change, people who are going to be better informed than most of the general population by the time we leave law school about the ways that law affects all aspects of everyday society, not just the particular area of practice that we'll individually go into. And so these different strands gave rise to the idea for the Lawyers Community and Impact series. And we had two last spring, a couple of events last spring where we picked important cases and had panels of professors talk about those cases with an alternative view to the way the first-year casebook presented it. And today is the third in the series and the first of the year, with the topic today being, who polices the police? This is obviously a question, and the hope is with this whole series that the questions will share this characteristic. This is obviously a question that is very vital to us. It's very relevant to things that we read about in the newspaper every day, things that we watch happening around us. And so it enables us through getting together, through having conversations, through getting to know the views of each other, as well as faculty members outside the classroom, about the importance, the impact of these events and the ways that they fit into our lives as members of our larger community. So I'll cede the podium to the faculty members who you came here to see today, but I really did want to just really welcome you and express personally how important it is to me that and how rewarding it is to me to see that so many of you have come, and I hope that this will become a really meaningful part of your law school, your time here in law school, as we have more events in this series. And so thank you.
Hi, it's so nice to have an event where we have an overflow room. I hope you feel like a rock star, Jeff. Jeff does feel like a rock star, and you'll see why soon. So first, I want to thank Dean Lester for really conceiving of this effort, and I think she framed it beautifully where it came from. And one of the things I really want to emphasize is that over the past few years, students were really experiencing, and all of us were witnessing what was going on in the world around us. And I thought it was fascinating that students really took that opportunity to ask questions of us as a law school, to say, how does what you are teaching us, how does it connect to this world around us? And some of that caused us to think about our curricular issues, as Dean Lester referred to, but also about the kind of programming we could put before you. This year, we decided, because of the interest that was generated around some of the issues around police reform, and also because it was an election year, to really focus on those questions as thematic throughout the year. So you'll see this. I just wanted to flag that our next event is on, where's Yadira, the 29th, I believe, and it's Richard Berfault and Dale Ho from the ACLU talking about voter ID, which there were a bunch of cases decided this past summer, and of course it's a big issue going into the election. And we're also going to have an opportunity for students and also alum and our broader community to engage in what's called voter protection activities, to get training in it, and we're setting a date for that, and we'll be providing more information on how to engage in that. So the conception of this whole program is it's a way to connect to us as faculty around these kinds of questions, but also opportunities for students to engage in community projects, some of which we have already started thinking about, but others of which we can develop together, right? So we have to think about this as an ongoing project. So I want to introduce Jeff Fagan so he can talk about the topic at hand, which is policing the police. And let me just say that this is a topic that I think is just a critical one to begin with for a range of reasons, and also presents some challenges. For many of us, it's a deeply emotional issue. We have strong feelings about the question, especially of police killing citizens, of police-citizen encounters. We have lived experiences of that. And the challenge for all of us is how to take all the different perspectives that we bring to this and channel it into a mode of problem solving without seeming to, at the same time, diminish any of the emotional impact of it, right? And so I just wanted to put that out there, that it's an issue where last year we had a series of conversations, and over the last 2 years, about police reform, and sometimes students left those feeling like it wasn't enough. I wanted to hear more. If you feel that way after this conversation, just know that it's an opportunity to have different kinds of conversations about this question in our community. They'll take different forms. Some of you were involved with the Broadway for Black Lives Matter over the summer, and some of you will be continue to be involved with that going forward. There are many ways to be engaged in this issue. Okay, so with that, let me introduce Jeff Fagan. So Jeff Fagan, many of you know Professor Fagan. His research is about policing and the legitimacy of criminal law, about neighborhoods and crime, about juvenile crime and punishment. Unlike many of us law professors, he doesn't just speak his opinions, he also does empirical research on this, and which is always helpful because you get data and facts. So one of the key things that is particularly I think that Jeff has been involved with, it's particularly important here, is that he's been an expert in real cases. So he was an expert in the New York stop, question, and frisk case, is how he terms it. Those of you who are in civil procedure this year know that we are studying the case and taking it through the entire litigation. So first years, really, you can connect to that and ask him questions about that. And he was an expert consultant to the special litigation section of the Civil Rights Division recently in its investigation of the Ferguson Police Department. So he's a great person to talk to us about cutting-edge issues around police reform and the role of litigation and its relation to other ways of reforming the police. So he's going to talk for as long as he wants to talk, but we are going to leave time for questions, and I may prompt some questions as a moderator. So let's turn it over to Jeff.
Thank you. So what Professor Johnson didn't say is that in when I don't feel like talking about happy topics like the police, I spend my time doing empirical research on capital punishment.
Oh yeah, I forgot that.
So I really, it's a wonder that I'm not in a mental hospital with this line of work. So what I want to do, so this is a huge topic. Let me just give you sort of a very quick historical frame. In between 1964 and 1967, there were riots there were 247 riots spread across 49 American cities. This is pretty well documented by the Kerner Commission report. If you can get a copy of it, you should look at it because, unfortunately, very little has changed between 1967, when that report was published, and today. And that's something important to bear in mind. This is a very, very difficult area in which to move institutions, both political institutions and government institutions, particularly the police, but also the political institutions that oversee and regulate the police. It's really a conversation to be had about police governance. So if you read the Kerner Commission report, now I have a copy of it. I have a library's copy in my office, so it may not be there, so you can come look together with me. But the first 50 pages essentially go through case studies of riots that happened in Detroit, in Newark, in Los Angeles, and a number of other places. And in virtually every one of these places, the spark for the riot was simply people in poor communities, predominantly African Americans, couldn't take it anymore in terms of police abuse. And there was an incident that was a spark that set off every one of those riots. And the one in Harlem as well. They actually didn't do the Harlem's case study, I don't think. They did Detroit and Newark. Newark's actually unfolded very much like the New York one did. But some of them were very mundane, just simply a hassle between a police and a citizen. Police officer stops the citizen, he hassles him, asks for ID, he asks him questions, it's kind of harsh. Citizen basically resists. He says, leave me alone. Why are you talking to me? Police officer goes off on him. And there are eyewitnesses. So these were physical bodies witnessing as opposed to today's videotapes and cell phone videos. And every time, so people would witness this and they had had enough. And this story is repeated throughout these case studies in the Kerner Commission report. And so here we are today, 50 years later, and you could actually pick up the Kerner Commission report and figure out an awful lot about American policing then that's not terribly different from what it is today. And that's, I think, what we want to talk about today, is the efforts that have gone on really over the past 22 years, starting with the Violent Crime Control Act of 1994, which was a very rough piece of federal legislation, but embedded in there, and in part as a give back to the Black Congressional Caucus, was something called Section 14141. And if you look at Section 14141, that allows the Civil Rights Division of the Justice Department to bring civil actions, and in some cases criminal actions, although the bar is very high in the criminal action, against police departments, and bring them to court, either through a court order, if they go to trial, as was the case in New York, or through a consent decree. And that kind of sets the stage for what I want to talk about today. What are the prospects for police reform? How is it working? And what are the critical issues? So I want to talk really only for about 10 minutes, maybe 12, and turn it over to you because this is your time to ask questions and really set, I think, an agenda that I'll learn from, as well as hopefully giving you some information too. So I want to talk first about what the mechanisms are. So I mentioned 14141. All of you probably know from your first year curriculum, and those of you, have you done 1983?
Not yet.
Not yet. Okay, well, you'll learn about Section 1983, which allows individuals to sue police departments and other government entities for violating a range of policies and procedures. Almost all of these involve, the ones with policing, involve torts for excessive force or false arrest and so on. So this 14141 is wholesale. You bring the entire department to task. 1983 is retail. You go officer by officer, incident by incident, and they're very different. The Floyd case was actually a civil rights action. It was litigation, class action suit. Wasn't under really 1983. It was just a class action suit alleging Fourth and 14th Amendment violations. And it's gotten quite a bit of publicity. If it comes up, I'll be happy to go into the details of it. But that was a different form. And it was the first instance, going back as far as the 1950s, where a federal court issued an order which looked an awful lot like a consent decree, but it was an order. You shall undertake the following specific reforms. And they listed out a menu of what those reforms were like. In other places, there have been some attempts to use civilian control through democratic processes. In other places, there have been citizen collaboration initiatives that have developed together with the police department. These are generally small departments where the political stakes aren't nearly as high as they are in a place like New York or Chicago or Philadelphia or Los Angeles and so on. But these are very, very interesting experiments. There is one, I think, in Lowell, Massachusetts, in the wake of a pretty bad racial profiling scandal in East Haven, Connecticut. There have been some efforts to bring community and police together with city government in East Haven. And they're doing some interesting reforms to rethink what happens inside the police department and in the connections between the police department and the community. Political reform is tough. Just a quick case study about our city. There were a set of procedures and statute ordinances really passed during the spring and summer of this year that would require the police department to do things like, for example, when they stop and frisk you, to give out a business card, et cetera. Things that you would think would be fairly simple and things to do. This was going to be done by order, by law, city council statute. The police department threw a fit. They got the mayor on their side, who said, well, we don't want to do this. The city council threw a counterfeit and said, we want to pass a law. What do you mean you're not going to implement the law? And the speaker of the city council basically caved to the police department and said, well, we'll let things bubble up from within. We've given them a set of guidelines and goals that they can pursue. Let's see how they do it by themselves. And Commissioner Bratton sort of won that political fight. So political reform is really, really hard to do, as is internal reform. And the one place that's really interesting that I think is on many of our minds is Dallas. And Dallas is an example of a police department that has done a really remarkable reform job. And of all of the places to be victimized in the way that it was, that's really just one of these cosmic injustices that we see, unfortunately, all too often. But they could have picked really a different place. Those guys were really good. And the lesson from Dallas is both reform from within, that the police chief, the commissioner there, convinced the department, the rank and file, including the union, that they really had to change, that things really had to change. And they did it. And so there are very, very few police commissioners like David White, very, very few. But they're out there. And they need a kind of a nurturing environment, both politically from the top and from underneath from their officers. And that's kind of hard to do. So unfortunately, that remains an exception more than the rule. But that's part of the landscape that we work in. So here are the critical issues that I think are facing us. And I want to go through this list, briefly talk about them, and then turn it over to you. I have some more stuff that we can look at in some detail. Well, maybe one more after this, but then you'll see. Okay, so let me skip over this for a second and do this. Generally, there are 20-some-odd consent decrees. These are the cities where the consent decrees have been in place, going back to the first one. I didn't list the first one, which was Steubenville, Ohio, which is a very small community. Pittsburgh was probably the first large city. It was a use of force consent decree. It was roughly 1997 or so, 3 years into 14141. These are the rest of them. I can give you one very brief story about the New Jersey State Police case. I worked on that case for Governor Corzine at the time. The state police wanted to get out from under the consent decree. And this is 7 years into the consent decree, so they form a commission. Commission was headed by James Johnson, who was a partner at Debevoise. Some of you may have met Jim. And Jim hires me and a couple of other people. We look at all the data. We analyze the data. We use our best statistical magic on the data. And lo and behold, we find 7 years into the consent decree, they're profiling their brains out. And this is unfortunately all too common. It's actually the case in the Los Angeles Police Department consent decree as well. They don't work too well, is the long and short of it, with the exception maybe of Cincinnati and maybe East Haven, but we'll get to that in question and answers. But so you get a sense of the scope of this. This is all over the country. I think Seattle, Portland, Miami, Oakland, Cleveland, Baltimore, New Orleans, the Maricopa County Sheriff's Department, which is now in a contempt order because Sheriff Joe Arpaio has refused to comply. They are all active. Newark is active. Detroit is active. Chicago is about to go online. They're negotiating the terms. Albuquerque is active, and so on and so forth. So you get a sense about the degree to which the Justice Department, on a very thin budget, is in the business of regulating what the police do and promoting the reform of police departments spread across the country. So these are the critical issues, I think, that we have. I'm sorry, I keep starting over one thing that I want to get to. This is what they do. These are not terribly creative, I have to say. They all believe that they have strong faith in training. They have strong faith that somehow if there are detailed records that can be aggregated up to monitor the performance of a department, that will somehow shed light, and that transparency, in the best version of transparency, will actually bring about some good. There are critical incident investigations. When something goes really wrong, there's an investigation, as if, for example, as we do in hospitals, when a patient dies, they sort of circle the wagons and talk in great depth about how this patient died, what could be done to avoid doing it again. Early warning mechanisms to identify police officers who are trouble, who repeatedly have incidents of wrongdoing, whether it be excessive use of force or false arrests or making arrests that somehow continue to fall apart in court. Body cameras are seen to be some kind of panacea. Body cameras may or may not be a panacea. I think it's a little early to tell. There have been some empirical studies of places of body camera interventions in small departments, which seem to suggest a reduction in Fourth Amendment violations. There are other places where body cameras, we don't know. And in at least one place, and probably a second is going to happen soon, the police unions have jumped in and said, no, we don't want to do this. We think that there's an invasion of privacy of the police officer. They come up with a number of different reasons. In Boston, they went to court, they went to the local court, to the Suffolk County Court, and they threw out the injunction. They're now appealing it to a higher state court. And New York is negotiating under the Floyd order for an experiment randomized trial, very high-level, sophisticated research design, the department is about to go to court there, arguing that this is a violation of collective bargaining. This is something that should be decided in collective bargaining. It shouldn't be decided through some kind of legal procedure outside of city government. And many of them do citizen surveys to see if lives of people's interactions with the police have improved. Sometimes they ask the right questions, sometimes they don't. We've done citizen surveys in New York. We've done it with kids. We've done it with adults. I've done it with Tom Tyler and with Tracy Mears and my colleague Amanda Geller downtown, and we found some pretty awful stuff. Now, whether or not they're using the right questions in these other surveys, we don't know. But this is the general design. It's not the most creative set of designs. One could think of other ways to do it. I'll give you one example in Cincinnati. There were a series of collaborations done between citizens and police, where they would all sit down at the table, look at the data about where the crimes were, what kinds of crimes, when they happened, who committed them, and they would plan strategies jointly, together, collaboratively, citizens and police together. There were internal collaborations within police departments to break down unit walls, to sort of dilute the police culture, which is a powerful culture. In other words, having the detectives work together with the guys who were in the canine guys, or maybe the horse guys, or maybe the forensics guys and women. And they would work together outside of their everyday silos, which really did help, I think, dilute some of the power of that culture, the reinforcing mechanisms of that culture. So these are the general designs, and I think the more interesting creative reforms have gone on outside of this regime. So let me get to what I believe are the critical issues. One is, who are the police? Are we hiring the right people to do policing in the 21st, into the second decade of the 21st century? Are they the kinds of people who have this cognitive capacities, to discern real suspicion from other forms of sort of narrated or scripted suspicion? Are they the kind of people who have emotional regulation so they don't go off when their authority is challenged? There's some interesting research about hypermasculinity being one of the driving factors in police use of force, excessive force. We could be screening people on those indicia, those dimensions. We need to think really carefully who the police are in this day and age, and how they manage people and how they manage interactions, and how they view law. We find there's an extraordinary amount of legal cynicism, which we know exists in communities, exists within the police department. They believe that the institutions that regulate them, the laws that they're supposed to enforce, are all somehow ineffectual or just barking up the wrong tree. Second issue is transparency versus secrecy. Transparency is a really hard sell. Much of what goes on is still secret. Much of what we know about the police officers is still secret. And I can point you simply to Section 50A of the New York State, it's not a constitutional act, it's in Civil Rights Act, which basically says the citizens of the state of New York are not allowed to see the personnel records of anybody in a police agency and other government agencies as well, but mainly police agencies. We don't have that shield, I believe, for teachers, but I can be corrected on that. But we do have it for police officers. So, for example, no one has seen the personnel records of Officer Pantaleo, who administered the chokehold that killed Eric Garner in a couple of summers ago. The incentives for police reform are not very strong. They sort of wait it out. They can sort of do minimal compliance and kind of wait out the tide, the 6 or 7 or 8 year period under which they're under supervision. The incentives really don't change. Arrests are still valued. Whether or not they turn into good arrests or bad arrests, nobody's really paying that much attention to them. So the incentives are really still pretty much intact the way they were before. There's no incentive, for example, for citizens to encourage citizens upon an interaction with an officer to file a positive report about the nature of that interaction. There's nothing. The policing model itself, we all know about broken windows policing. We all know about stop and frisk. We know about a fairly low level of suspicion. We know about enforcement of order maintenance. But there's a conversation to be had about the interaction or the extent to which the policing model drives the number of bad contacts between citizens and police. I would guess that if we were able to do this, and it would be a little bit hard to do empirically, we could compare police departments and those that actually have moved away from broken windows and are pursuing other forms of policing. And again, Cincinnati comes to mind as one of those places. Probably have lower incidence of use of force, excessive use of force, lower torts, fewer payouts, and so on. By the way, under incentives, there's a series of articles written by a scholar at UCLA, Joanna Schwartz, who's documented the payouts that have gone on and whether those payouts have actually created any kind of deterrent effect for a police department. And the answer is no. So in New York, for example, New York paid out during the 12 years of the Bloomberg-Kelly administration in policing, over $1 billion to settle 1983 and other class action lawsuits. It's $1 billion. You can imagine what else could be done with that $1 billion. But as the payouts mounted, nothing changed until Judge Shindlin until the moment of the class cert ruling, which basically told them that we were going to win. So it's really the incentive. There just isn't the incentives. There's some conversation, for example, that maybe the police union should be taxed in a way that sort of proportionately to pay for some of the problems that are paid out from wrongdoing by their officers. Perhaps it should come out of the general budget. No one's come up with a good fiscal solution on the fiscal incentive question. And so there's a lot of payouts that are still going on. Monitors are really important. Who is the monitor? Years ago, we looked at all the monitors, maybe the first dozen consent decrees, and we found that all of the monitors came from the same 3 firms. This is a big business, monitoring. It's very expensive to monitor a consent decree. And so there are firms that are put in place that have formed around this thing. They're sort of collaboratives between management organizations, management consulting groups, and so on and so forth. And they'll hire people like me to do some statistical work on this. But it's huge amounts of money. And there's 3 of them. And you can imagine the conflicts of interest. If you are too tough as a monitor in City A and you're bidding on City B, well, the police who have to consent to participate to this are going to say, we don't really want that guy from City A. He was too tough on the police. He's biased, so we don't really want him. So there's a problem with monitoring, both in terms of what the monitor does and how he or she does it, and whether or not these folks are really sort of thinking in a way that challenge or thinking independently of the institutions that they're looking at. Unions are huge. They basically are running the show. say that again. And I don't like being anti-union, and I'm not anti-union by any means. This is an exceptional form of union advocacy. You should, if you get a chance to look up the Law Enforcement Officers' Bill of Rights, you should. It's an extraordinary set of protections for police that ordinary citizens don't have when they're accused of wrongdoing. But when police are accused of wrongdoing, whether it be corruption, whether it be causing injury in some kind of an assault situation, they have protections that none of us have. There's a really interesting article that's being published by the Law Review here by a woman named Kate Levine, I forgot where Kate is teaching, basically saying, well, gee, these are really interesting mechanisms. Why don't we just simply extend the same protections to citizens who are arrested as well under the same circumstances? I'd imagine that would be greeted in some kind of with some skepticism. Let's leave it at that. Political intimidation is true. The unions actually do, and the police do intimidate police officers. We've heard narratives now about depolicing. We believe that one of the reasons why crime has gone up and violence and murder have gone up in a handful of cities around the country is because the police, operating into what they call the Ferguson effect, meaning they're afraid of being called out for wrongdoing, have essentially depoliced. They pulled back, and all of a sudden now criminals are running the show. And so the threat of a police strike always looms over political activity by city executives, by mayors and city councils, and they worry about it. There was a certain amount of intimidation that went on over simply this summer, the story about the new work rules that the city council had put into place for policing, and they basically said no. And I think the last issue is whether or not cities want to get involved in a meaningful way to regulate police in the way that they've done with, say, for example, school teachers, which is a state issue but also a local issue, or with any other kind of union, or with any other kind of government function. There seems to be some kind of reticence on the part of political leaders to get serious about even just the basics of administration, personnel rules, standards for certification and decertification. It's actually very hard to fire a cop. Just any form of regulation of the police agency should be a matter for city governance, and yet it's not. And so the governance question looms large in the background, and I think it remains to be seen, or to be understood fully why governance, why there's such reticence to really dive deeply into city governance. So let me leave it at that and throw the floor open to you guys. And I want to hear your questions, and we'll answer them as best we can, and go for it.
Okay, all right, so that's great. Let me throw out a first question. It's a large question, so just you can answer it briefly, and then we'll take questions. So it's about the notion of incentives, and we can all think about what that language means, right? Incentives. But I wanted to ask you about whether you thought there was some hope for federal government incentives. So these police departments, they receive a lot of money from the federal government. The federal government could attach strings to that money or require them to engage in certain kinds of policing. Do you see that as a promising avenue? And then another kind of incentive is political mobilization and social movements, right? The pressure that they place through the political process. So what do you think about those? One is more technocratic and one is more about politics and social movements. How do you see that?
I don't think that there is a history of federalism with respect to disseminating block grant money to police departments around the country. But of course, the federal government has diverse viewpoints. And so for years, throughout the 90s and maybe the first half of the last decade, right up to about 2010 really, there was a federal block grant program called the Edward Byrne Block Grant Program, BYRNE. And Eddie Byrne was a police officer who actually was killed in New York City during about 1986, 1988. While sitting in his patrol car, somebody walked up and executed Eddie Byrne. They named a grant program after him. And one of the way that you had to apply for the grant, the city would apply for the grant program to the Bureau of Justice Assistance, which is within DOJ. And the justification, to show that you were worthy of getting the grant, you had to show a number of different performance indicia of what your department was doing. And the first and most important performance indicia was how many arrests you made. So, this is kind of a perverse incentive to show that you're interested in some kind of process of reform. I don't know what that would be like today. I don't know. We could take, for example, President Obama's 21st Century Task Force on Policing and operationalize all of the dozens and dozens of recommendations that that group gave, and say, here are the things that we will fund you to do, including decertification procedures, for example, including greater transparency of disciplinary practices. It's quite possible. Is there political will to do that? We don't know, but it is within the realm of possibility.
All right.
You spoke about the success that Dallas had in reforming its police practices. I wonder if you could speak to what some of those reforms were over and above the ones you pointed to as part of 1441 compliance, and particularly the ones that might have some applicability outside of like an international super city like Dallas, or New York, towards smaller cities, places like Georgia.
So one of the things they did was change their policing model, and they backed off all of this broken windows stuff and stop and frisk stuff. They did concentrate on areas that had fairly high crime rates. The idea of community policing is a bit sort of inflated. It's a big space. It can mean many different things. What they did, though, was actually take it quite seriously, put police officers on the beat every day in those communities and encourage interactions. They did things that were actually greeted with a great amount of cynicism in the past, things like having police officers get involved in athletic programs with kids, both female officers with young girls and male officers with guys. They made themselves open with respect to police complaints and made those data visible. There was a great deal of transparency. But I think the thing that David did that's most important was he started to change the profile of a cop. And they sort of marginalized the bad cops and brought in new guys who were and he screened them for this level of commitment to community. And they didn't get into the residency requirement thing. I'm not sure there's really good evidence that residency requirements really matter. But he did get into the notion of can officers have meaningful interactions with citizens in a way that just simply breaks down that barrier. And that was maybe the most important thing that he did. I said at the top, who are the police? And I think he took that question really seriously.
So my question is related to the Dallas incident as well. So just given all of the reforms that the Dallas Department undertook, what I did notice that was really striking during the incident of like the suspect killing the police officers is the way in which they killed the suspect, and that was with the robot bomb.
Yeah.
Which was unprecedented, the first time ever that a suspect on American citizen who so happened to be a suspect was bombed by a robot on American soil. So I think that's very unprecedented. It is factually. So my question to you is, what are your views about police militarization, the 1033 program that gives military weapons and surplus to police departments? Do you view that as maybe counterintuitive to police reform?
Yeah.
Especially given the fact that when we do see these protests and riots related to police brutality, you'll see Humvees, you'll see tanks in response to community anger.
I think on the robot incident, the robot killing, my guess is that if they could walk that one back, they would walk it back. I don't think that. I think that was done, and I hate the term fog of war, but I think that was done in fog of war, and I think they would probably do it differently, knowing as much as I do, or what I do about them. I would get away. I would do away with 1033. It's just simply it's a powerful narrative about warrior cops, and understanding the demand for that kind of military equipment is really important. There's a book by Washington Post columnist, and it's kind of a libertarian guy, Radley Balco, called The Rise of the Warrior Cop. And he talks about the populating the ranks of the police with ex-soldiers, or people who have that kind of model in mind about what kind of police officer they want to be. And he believes that profile of individual and the views that they express and their preferences and so on actually do work into the DNA of the police department. But they also, I think there's a belief that if you ask police officers, they say, well, the bad guys are really heavily armed. which goes to gun policy, but they have very, very sophisticated, high-powered weapons. We need to be able to match them on the battlefield. And they would say things like that. So you can get a lot out of that narrative. Bad guys are armed. Sometimes they do have powerful weapons, but the police already have powerful weapons. Why they need more is something else. I think that 1033 is the kind of thing that creates its own market demand. You know, you put it out there, two people, one department sees the other department and say, wow, that's really cool stuff, we want it too. Because we're really afraid, we're terrified. One of those profiles of the new cop is the guy who has the ability to discern real threat from non-real threat. But that, when you aggregate that up, you see the sense of real threat aggregating to a demand for armament. I just simply think, you know, years ago, you all know about, I'm sure, President Eisenhower's military-industrial complex speech. This is the military-industrial complex on steroids. So I agree with you. You know, it's the kind of thing that I think it's a political thing, and so a mayor's going to spend some political capital to go up against the police department when the police commissioner is saying, my guys really want this stuff, I think we need it. So then the mayor has to decide how far am I going to go to oppose these guys in this. It's a tough nut to crack.
Okay, so I see several hands. There's one up here, and then I'll get you two back there. So why don't you go first?
You mentioned sort of two remedies, one from the Justice Department under 1411, one other under Section 1983 for an individual. Wondering if you could speak to maybe two ways in which the burdens of those cases might differ. The first being, if I brought a case individually, presumably I would have to prove that discriminatory police practice harmed me, whereas maybe a Justice Department has broader definitions of harm. And then the second is, does the sort of Washington v. Davis standard apply to this issue, and how would it differ between a suit brought by an individual versus the Justice Department?
So 1983 alleges a violation of, generally, of internal policy and procedure which produces a harm. And so the burden is a civil burden, and it's not, it requires, it's not a Washington v. Davis thing, because 1983 doesn't necessarily have to allege a racial component. It could allege a racial component, but by and large it's really more use of force or wrongful arrest, deprivation of civil rights, and so on. So I think it's kind of a straightforward factual claim by a preponderance standard. If not, what's the standard?
Yeah.
It's preponderance.
So I mean, the issues are. I mean, it's definitely preponderance of the evidence standard, but the intent requirement is not going to be a barrier if you're not bringing a racial
it's more
discrimination.
Yeah.
And it's a Fourth Amendment claim. You know, it's an excessive force Fourth Amendment claim. There are plenty, as you, those of you, everyone in Civ Pro will learn. There are plenty of barriers and hurdles to bringing it. You learn about this in Fed courts too, to bring Section 1983 claims, but they are straight up Fourth Amendment claims. You don't have to show intent. You do have. There's a whole arcane doctrine about whether or not there's the well-established law. I shouldn't say it's arcane, but it's hard to get around. Whether or not the police officer has violated well-established law
or internal policy.
Or internal policy.
Right. 14141 basically.
Barriers.
14141 basically says under color of law that you deprive people of their civil rights under color of law. Whether intent is on the table or not is something else. If there's a 14th Amendment claim thrown in, then we have to start. Then there has to be conversation about go beyond disparate impact, maybe go beyond disparate treatment to show that there was some kind of discriminatory intent. I think Judge Shinlin really wrestled with that really cleverly and effectively, but I don't think the Second Circuit agreed with her. But she basically had kind of two arguments. One was, if it's not race, what is it? And I think this is interesting because the evidence was exhaustive in terms of ruling out any other possible explanation but race. And the other thing she said was really very interesting. She married the 4th and 14th Amendment claims together and said, if you get it wrong so often when you stop people but you find nothing, and you're only doing it to people of color, then clearly there's a problem with the 4th Amendment basis of all of these stops that you're doing, and you're violating the 4th Amendment by doing the incorrect stops, the erroneous stops, wildly more often to minority people. So there, how do you fashion a statement of intent out of that? If it's not race, what else could it be? And I think there was a pretty interesting way to deal with it, which is not to say that this is not a really high bar, and it is a very high bar. But 14141 does not necessarily force the city, the people bringing the claim, to make an intent claim. They don't really have to. It's simply, did you deprive me of my civil rights under color of law?
Shang-Chi, back there.
My question was going back to body cameras, because I feel like, since Rodney King, we've had a lot of visual documentation by various people, and especially recently, for example, with Eric Garner, you had it on video. So I was wondering why body cameras are kind of seen as this panacea when we do have so many people actually reporting a lot of the police brutality that's going on. I was wondering why just having it on the police and having that on the source, why it makes that much of a difference.
I think there's a kind of optimism that there are different levels of violation that police can do. There's a bad stop. It's simply an unconstitutional stop. This is sort of low level, may not seem low to you or to me, but it's a low level in violation of individual liberties that happens at kind of an everyday routine basis. I think the expectation is that those kinds of low level Fourth Amendment violations would be the ones that would be the most impacted. And that the more egregious cases of physical force and lethal force or near lethal force would not be impacted as much. They would be impacted a little bit because they might be less likely to have an incident spiral out of control if you didn't stop the person on the small stuff. It wouldn't get out of control and get to the big stuff. I think there's also an expectation that police officers, if they actually do resort to force, will be able to, they believe that they'll be able to defend themselves, camera or no camera. And the video evidence can often be very vague. If the audio's not good, if the camera's off or somehow pointed in the other direction, some of this came out in Baton Rouge protests, video can disappear, which it has. So I think it's kind of a bit of more of a prophylactic hope that it will stop the low-level stuff than it will to stop the high-level stuff.
Okay, there was a hand right there. And
Could you discuss a bit more what empirical data would be helpful in assessing police reform? Because you mentioned...
I'm sorry, say it again. What would...
empirical data would be helpful to assess the success or failure of police reform? You mentioned arrest rates as creating a perverse incentive and maybe not being the most helpful. But what are we missing there? I mean, assault rates, death rates, these types of things, and
yeah. So I'll tell you, answer a little bit by anecdote. About a year after the Floyd verdict came in, Attorney General Schneiderman asked our team to investigate what happened to the small number of arrests that pursuant to stops that got into the courts. What kinds of charges got into the courts? What happened to those cases in the courts? And we found that, by and large, nothing serious stood up. What got into the courts was predominantly misdemeanors, very, very rarely were they felonies. Most of them were broken windows kinds of offenses. When they did get to court, more than half of that particular set of cases never got to court. They were either nullified by the desk sergeant, who said this is crazy. The DA took one look at them and decided not to prosecute, the declination rates. Or the judges took one look at it and said, "You're out, goodbye, you're out of here." And they dismissed the case. So I think one way to study whether or not policing, what kind of job policing is doing, would be to actually look at those kinds of patterns for stops, for arrests, for any other kind of action. Second would be to look at the use of summonses. So one thing we were not able to do was to look at summonses. Summonses are a way to get people into court, even as a civil matter. If they don't show up to respond to the summons or they can't pay it, as was the case in Ferguson on traffic violations predominantly, but other violations as well. My favorite in Ferguson was people being cited for having high weeds in their gardens, and they would simply ignore it, and lo and behold, they wouldn't pay the fine, and they would have an arrest warrant issued. So looking at the summons regime as it converts into a warrant, an arrest warrant for failure to appear, which converts a civil ordinance violation into a criminal matter, that would be one area to look at as well. I think we'd actually want to look at citizen complaints and take them very seriously and create a space where citizens can actually file complaints. I think if you ask most citizens in New York about whether they can file a complaint free of the potential for reprisal by a police officer, they would say no, and particularly in minority communities. I think we've got to take that really pretty seriously and create a safe space for that to happen. I think we want to think about officers themselves. And as somebody who does pretty complicated empirical stuff on empirical research on this stuff, I would ask the question, I would start studying officers instead of incidents. And very few places are doing that. We would ask the question very simply. If you look at an officer's career or activity over, let's say, a 2-year period, I would want to know if this guy was getting better or this woman was getting better. Were there fewer incidents of force? But more important, was this person making stops or arrests that actually were good stops or arrests? Or do they continue just simply to get it wrong? And looking at the performance of officers is something that just hasn't really happened widely. And I think that would be maybe one of the most important metrics to pursue.
And just as you mentioned that, I want to make a plug for interacting with Phil Goff, who is teaching a seminar on policing, and he's a cognitive psychologist, so he approaches it from a lot of different angles and thinks about the profile.
He's a social psychologist.
A social psychologist.
He would get furious.
Sorry. He's a social psychologist, not a cognitive psychologist, who thinks about this from the vantage point of also the sort of the police profile, and these questions about hypermasculinity and also fears of racial threat formed a lot of his research. He's teaching a seminar this semester and next semester, and we'll probably give one of these talks next semester. So I think we have time for one more question. Is that how we're doing? What time do we go to? 1:10? Okay, so let's go to my board.
Well, just back to body cameras. My question is about what you think its best use would be. So in the case of Eric Garner, where we have video evidence and it can't get past the grand jury, is there something administrative? Is there some other way to use that material?
I think it's very hard to get it out into the public. One of the terms that is negotiated, and here's where the unions play a huge role, is making sure that data, and it really is data, is kept private to the extent possible and not put into the public domain where it can become a topic of political conversation and debate and so on, and be used to vilify an officer who may, for better or worse, be exonerated, that his actions were defensible. So I don't see that. I don't see total transparency on videotape evidence. And if I were a defense lawyer, I probably would say I don't really want that out in the public. I want to be, if my client is going to go to trial, I'd like it to be something where there isn't a public trial at the same time that there's a courtroom trial. So I see it being guarded. But there's a different issue. If you're going to use if you can use videotape evidence as a way to monitor the police, then people are going to have to look at this and they're going to have to evaluate it. Now, think about this is an enormous task. You've got hours and hours and hours of videotape that has to be viewed by people who are capable independently of rating the behavior of the officer with, at times, complete information and at times incomplete information. So maybe the audio is not good. Maybe it's the camera's at somewhat, for whatever reason, maybe it's muffled. Maybe there's a wind is, but whatever it is, you can imagine the audio being compromised, the video being somehow, somewhat not totally conclusive. And you've got rater bias. So you'd have to have 3 people looking at one videotape in order to resolve what actually was, what everybody agrees what happened during that incident, plus the officer's account, plus the citizen's account. So it's great that there are body cameras and there's going to be a record in case somebody wants to bring up a case, and there is a record, and I think can sort out what happened in that case to some degree. But to use that data as a way to monitor what the police do is really going to be extraordinarily hard. You'd have to sample it, I suppose, just take a random sample of incidents and have people look at these things over time. You might argue that we should only be looking at the videotapes of officers where other problems have come up, so that we very carefully look at who those officers are. You kind of manage the task of looking at the videotape. But you have to kind of really think hard about what you're looking for. And, sometimes the camera goes on, sometimes the camera goes off. Maybe police officers should be sanctioned when they turn the camera off. Sometimes we have to think about what happened before the camera went on, because there were antecedents to a particular incident. But here's one thing that's actually pretty interesting about videotapes. So we have videotapes. And we take statements from officers when there's a matter, a disciplinary matter or a criminal matter or a civil liability or civil litigation. When do you ask the officer to give her or his statement? Before the officer's actually seen this videotape or after? And there's a couple of experiments going on, psychology experiments, about whether narratives change after one has seen a videotape, the power of the videotape to reframe cognitively how an officer expresses the dynamics of that interaction. And that's a very powerful thing to ask. So if you go to this union contract business and you look at the first column about the delay in the interrogation until somebody, maybe the lawyer and the officer, have looked at the videotape, and others have looked at the videotape, maybe there were other officers responding at the scene, so they can all sort of get their stories aligned, which is what happens. This is a really critical question about how we use that data, and it's up for grabs. And I think there needs to be some interventions by people like us into the discussions about how that videotape is used. But if you look at that first column, that's really powerful stuff. I said that I think unions are the biggest issue. And this is an example of the unions being the biggest issue.
So that had to be our last question. Let me just say thank you to Jeff Fagan, Professor Fagan. One of the things I just want to observe about Professor Fagan is that he has deep empirical knowledge about all this. He's generated some of the most important empirical research, but the thing I always appreciate about him is that he's been in these institutions that have been struggling with questions of reform. Our goal is never to depress people, but it is to inform you about the kinds of strategies we have to put into place. Absorb all this knowledge, take it to a good place, take his classes, take other classes that allow you to engage these issues. So thank you, Professor Fagan.